My name is Jennifer Pierce. I'm the managing attorney of Legal Aid of Southeastern Pennsylvania's Doylestown office. Our office provides assistance with family court issues including custody, dependency, and protection from abuse cases. A question that's often posed to us is, what are grandparents' rights in family court? I'm going to provide a brief overview of the law in Pennsylvania concerning that. In order to assess your specific situation, please consult with an attorney. You can also contact Legal Aid or the Bucks County Bar Association for assistance. A child can be legally placed with a grandparent under a family court order granting the grandparent legal and physical custody of the child. So first of all, what is the difference between physical and legal custody? Physical custody is the actual physical possession and control of a child. It can be granted solely to one party, it can be shared between the parties, it can be granted primarily to one party and partially to another. Can also be supervised by another individual or agency depending on the circumstances. Legal custody is the right to make decisions concerning the child's best interest. They include, but are not limited to, medical, educational, and religious decisions. This can be granted solely to one party, or it can be shared between the parties. Parents have the right to file for custody of their child. Grandparents and great-grandparents have the right to file for partial physical custody and supervised physical custody as well. When a court needs to make that determination, they will consider the amount of contact between the grandparent and the child, whether awarding custody to the grandparent will interfere with a parent-child relationship, and ultimately, what is in the best interest of the child. Grandparents who stand in loco parentis to a child, which means that they have assumed the duties and responsibilities of the parent-child relationship, can file for any form of physical custody. And in 2018, the law expanded the ability for grandparents and third parties to file for any form of physical custody. In order for a grandparent who does not stand in loco parentis to a child file for any form of physical custody, they must meet 3 requirements. 1. The relationship between the grandparent and the child must begin with either the consent of a parent or under a court order. 2. The grandparent has assumed responsibility or is willing to assume responsibility for the child. And 3, the child has been determined to be dependent, the child is subject to parental abuse and neglect, or the child has lived in the grandparent's home for over a year and has been removed from the home by the parent. Always remember that just because a grandparent has the right to file for custody does not mean that they will be granted custody. Oftentimes, grandparents and third parties will have to overcome a presumption in favor of the parents. Ultimately, the court must also use what is in the best interest of the child standard in order to determine custody. There are several factors that the court must consider when determining this. Among those include who will provide a safe, nurturing, and stable environment for the child, who will ensure that the child continues to have meaningful relationships with other individuals and family members, and ultimately who will keep the child out of dangerous situations.